It's Bernard Nomberg with the Nomberg Law Firm. We're back on another Tuesday talking about an area of the law. And I've got Jimmy Haggerty, a Vestavia-based attorney, here to talk with us. Jimmy, I appreciate you coming on this morning.
You're quite welcome.
And Jimmy's going to talk to us about an area of the law that not a lot of folks know about, but it involves employees who are hired and work for the federal government, and they get hurt on the job. But before we get to the nuts and bolts about that, Jimmy, tell us a little bit about yourself, your background, and so forth.
I've been doing OWCP work, which is Office of Workers' Compensation Program work through the Department of Labor, for a little over 15 years. Prior to that, I did a good deal of insurance defense work. And prior to that, I graduated here locally from the law school and went to undergraduate school at the University of Alabama in Birmingham.
Okay. So UAB and Cumberland are your two schools?
Birmingham.
Okay, very good. Well, Jimmy, let's get into this area about workers who are employed with the federal government and when they get hurt on the job. And my firm handles work comp cases, but it's different from what you guys do. We handle stateside work comp for folks who are employed maybe with private employers. There's also individuals who are state of Alabama employees, and that's a whole different avenue of administrative tasks for folks who get hurt on the job. But what we're talking about are people who are employed by the federal government. And give us an idea of what types of jobs those are of some of your clients.
FECA, which is the Federal Employees Compensation Act, covers just about any and all federal employee that works for a federal agency. I've represented people in the post office, the IRS, the FBI, and a multitude of other agencies, and it's basically similar to Alabama work comp law from the standpoint, if you're injured in the course of your business working for that particular agency, you would come under FECA and OWCP.
Okay, well, and OWCP again stands for what?
OWCP is Office of Workers' Compensation Programs. It's an agency under the umbrella of the Department of Labor, which is responsible for all federal employees injured in their work.
Now, are these types of claims and cases that you handle, are they administrative based? Are they litigation based? How are they typically handled?
They are typically administrative based from the standpoint that you have a 3-tiered level of appeals if your case is denied. The first appeal, you can either request oral argument or reconsideration. You have to do that within 30 days of your denial of your claim. The second one is a specialized reconsideration, which has to be done within a year of the denial of the claim. And the third one is ECAB, which is Employees Compensation Appeals Board, which is done in Washington, D.C., and you have to go up there and argue that in person.
Okay. Well, we'll go through a typical an example in just a minute, but if somebody is denied initially and they appeal that first tier that you just referred to, who are they appealing to?
They're appealing to the Office of Workers' Compensation Programs in Jacksonville, Florida, or London, Kentucky.
Okay.
And the claims examiner is given the request on the appeal. Then it's handed to us another officer that will view it like a new set of eyes, so to speak. Then they will render their opinion. But if you get an oral hearing, you get to give your side of the story, so to speak, before that hearing officer, before they make a decision.
And would that either be in Kentucky or in Florida?
Those are done by telephone.
Okay. Well, let's create a hypothetical and kind of talk about it for a minute. Let's say that you represent a postal worker.
Okay.
And the postal worker steps out of their truck to deliver the mail and breaks an ankle because they've stepped in a hole.
Right.
And then they come to you 3 weeks later. I got hurt. You know, they are right now. They're covering my medical care. What are you telling those folks? What are their rights?
Well, First of all, they're due to get all the medical help they need with respects to the work-related claim. Once they're rendered to be at MMI or maximum medical improvement, they may be in a position to get some type of monetary settlement depending on what's involved with the injury.
Okay.
And it's a lot like Alabama workers' compensation from a standpoint of scheduled members award, that type of thing.
Who picks the doctors or the medical care providers?
That's a bit of a problem from the standpoint they get to pick their own, but a lot of times, particularly right here in central Alabama, if you're a federal employee and you're injured on the job and you have to go, say, to the guy that did my knee surgery, his firm will not take federal employees because the Department of Labor is so difficult to deal with.
Well, that's what's going to lead me to the next question, was the logistics of who's actually paying for this and how does it get paid?
The Department of Labor pays for the entire claim once it's in the system, supposedly, and you get a claim number, and from that point on, it's a matter of going back and forth. It's kind of like a quasi Blue Cross Blue Shield, except that they're very, very touchy about making sure the things are filed properly in order to get paid for them.
Well, sure. I can see that with any work comp case, whether it's federal, state, or private employer.
Yeah.
What about from a situation when the employee first gets hurt? This postal worker we're talking about, he steps in the hole and he breaks his ankle. Who's he supposed to notify to say, hey, I got hurt, what do I do next?
He is supposed to notify his supervisor within 30 days of the accident.
Okay.
And that is done through a form called a CA1, whereby he fills out the front portion of this form, and the supervisor fills out the back portion. The supervisor sends it off to London, Kentucky, and that's when the claim number's set up.
And in our scenario, let's say that we now have an emergency because he knows he's hurt.
Right.
Can he just go straight to the emergency room, or how should he proceed or deal with that?
If it's a life or death situation, I would tell them to proceed on, and if the emergency room says anything, all federal employees have Blue Cross Blue Shield.
I see. And we can deal with the paperwork after the fact, the medical.
I'd rather seek forgiveness and ask permission of somebody at death's door.
Certainly. Okay, let's say that our guy had surgery and he's off work for 6 to 8 weeks because he can't walk at this point.
Right.
Is he paid any compensation or his salary while he's out?
Yes, again, similar to state workers' comp. Plus, he gets continuation of pay for 45 days until the workers' comp sets in.
Okay. And usually it takes, in your experience, how long does it take for that compensation to kick in when they've been off work?
I would say anywhere from 30 to 45 days.
Is there an adjuster per se, or is there a claims handler for these claims?
They have claims supervisors that are Department of Labor employees in London, Kentucky, and Jacksonville, Florida.
Well, it's interesting. I guess that's just our part of the country.
It's this region,
Okay.
southeastern region.
Okay. And our guy in this scenario, 3 months after he gets hurt and has his surgery, the doctor says, from a medical standpoint, you're as healed as you're going to be.
Right.
And he says you have an impairment rating of 8%. You're eventually going to be able to walk on your foot normally, but you need to ramp up, so to speak, to get to that part. And let's say that he does that, and we're now 6 months after the original injury, and all the dust has settled, so to speak, on his medical care, and he's done treating.
Right.
Doctor says, just come back if you need me.
Right.
At that point, what do you, as his attorney, what's the next step for the worker, the employee?
After everything is said and done and accepted, and he's at MMI, as a general rule, you'll get a letter from the Department of Labor saying you reached MMI on this date.
Okay.
Your average weekly wage was this. We've determined that the benefits that have been paid today are that, and then we're going to give you some type of a scheduled member award for this amount of money.
Okay.
And it's not done by any negotiation process. It's like, here it is. If you don't like it, you go through the same appeal process that you would follow if they had denied your claim from the get-go.
I see. And let's say that our postal worker doesn't like what he's being offered. He thinks that they're just wrong in the either
Right.
the calculations
Right.
or whatever it is. It's not enough money in his mind.
Right.
Then what?
Then nothing.
Okay. It's either take it or leave it.
It's either what I would like for y'all to do is take this back and check your math.
Right.
All the math is done right there on the letter,
Mm-hmm.
and they spit those things out of a computer on a daily basis, and that's just the way it is.
Okay. So where do you come in? I'm going to assume that you're mostly needed if it's a denied claim.
Correct.
Okay.
Well, also, my need comes in is if there's a third party claim. In other words, in this scenario, if he was stepping out of the truck and a guy rear-ended him
Okay.
that caused the damage,
Okay.
our guy would get a letter from the Department of Labor that said, through our investigation, we have ascertained that a third party
Right.
is responsible for your injuries.
Mm-hmm.
And what happens there is, the same letter, it says, we're putting the burden on you
Right.
to go
Right.
after the third party.
Okay.
So I also get involved with a third party claim, and then once you get the third party involved, you're responsible, being me or whoever's handling it, from a legal standpoint, you're responsible for protecting the lien from the Department of Labor for benefits and medical.
Right. Right.
You don't pay back $1 on $1. It's like Blue Cross.
Right.
There's a 20-item formula. You have to do all the calculations where it includes attorney fees, expenses, and whatnot. And at the end of the representation, the client gets monies from the Department of Labor, the insurance company for the third party,
Okay.
and then the Department of Labor gets part of their money back.
Right, and that we won't get too deep into the
No,
woods with subrogation today, but let's talk, and I appreciate all the this information that you're providing, because
Sure.
most folks who are federal employees really just don't have an idea of what they're supposed to do and how they're supposed to do it. So they've got a 30-day window to notify
Their supervisor.
their supervisor to make sure the claim is proceeding.
Exactly. And the burden is always on them. I stress that all the time. Don't even assume your supervisor is going to turn it in.
Well, Jimmy, I apologize for not asking you earlier. Folks who are watching this, whether it's live or later on, if they've got a case like this or want to ask questions, how do they get in touch with you?
My number in Birmingham is 205-822-1223, and I don't have a problem folks asking me general questions.
Okay.
I'd much rather answer a phone call and help somebody out rather than have somebody call me 6 months down the road and
Sure.
it's messed up 8 ways to Sunday, and it's kind of
The
difficult to get out of. Yeah.
the earlier, the better.
Yeah.
What if they want to email you instead? They don't want to talk on the phone. Would that be okay?
Sure.
Okay.
My email address is J as in Jimmy, A as in Apple, H as in Haggerty, at Gloor, Gloor, Strickland, Strickland.com.
Okay, and after this recording, we'll also put your contact information in the comments section. Jimmy, just a couple of things before we wrap up today. Talk to us just briefly. If oral argument is requested and granted, what kind of process is that?
The process sets up in such a way in that you're in the conference room with your attorney. The hearing officer is up in D.C. with the court reporter. And in effect, and this is the reason I always suggest to people, even if you don't hire me to do it, ask for oral argument on your own, because this hearing officer, for lack of a better term, is a lot of times, I don't want to say more educated, but more qualified to understand the ins and outs of legal, medical causation, that type of thing in these claims. And you get to give your side of the story, so to speak. And that hearing officer will have a much better idea after hearing the claimant as well as his or her attorney, in addition to the filings, sometimes voluminous filings of all the paperwork. You know, if you have claims that go on for years as far as medical information, that type of thing.
What's the statute of limitations or the time period that a person has to make a claim?
3 years.
So 3 years from the date of the accident itself?
I generally tell people 3 years from the day of the accident, yes.
Okay. What about exposures, occupational exposures to chemicals and the like, are those also could be covered?
Those could also be covered. The only difference is you file a different form. If it's a I don't want to say a standard work comp injury like a broken arm or a cervical injury, that comes under a CA1. If it's an occupational disease, say exposure to chemicals or whatnot, that would be a CA2.
So it's just a different paperwork, different path, same rights.
Same thing with death claim. There's a different form for that as well.
And what's the statute of limitations on a death claim?
Statute of limitations on death claims, the same statute, 3 years.
Three years. Okay. One last thing that just hit me. What are some typical reasons for denials that you've come across?
As a general rule, most of the denials I see is from a medical causation basis. Typically, on the legal causation side, they had a witness or some civilian reported that happened, that type of thing. But they are very they expect very precise documentation from all healthcare providers. In other words, they don't want a doctor. If you have a doctor that comes back and says, well, I looked at the history of the case, and based on what I know, it's work-related. That ain't going to hunt right there. It is not going to hunt. So what they want is the rationale he used and everything else from the standpoint of how he got from point A to point Z.
Sure.
And everything in between. Hence, that goes back to the problem that so many, particularly specialists, will not deal with federal employees. It's just not. It's not worth it.
One of the things that we constantly communicate to our clients from the very beginning, the very first time you see a doctor, tell them where it hurts.
Right.
Every body part, even if it's just something that you're not sure that it's going to be a long-term thing.
Right.
Tell them from the beginning, get it in documentation, and then that will be a basis that 6 months or a year from now, when you're still having those issues. Do you subscribe to that advice as well?
Yes, I do, and I also believe that once you start seeing a doctor, as we all know, you may hurt your knee.
Right.
And during the process, particularly after an automobile accident, say for a postal worker in a postal truck, you may have some other issues that come up. And they may come back and say, well,
that's right.
I only made the claim for the knee. And I said, well, my philosophy is, it's your right to make the claim for everything that was involved in that accident. So go ahead and file a new claim for the other problem you may have. The worst case scenario is they're going to say no. But if you wait down 3 years later and say, now I'm thinking that it did involve.
That's the biggest fight if you wait and you hadn't told anybody.
Yeah.
Well, Jimmy, all sound excellent advice. We appreciate you sharing your expertise and your knowledge. Again, how can folks get in touch with you?
In Birmingham, 205-822-1223.
Okay. Guys, again, this is Bernard Nomberg with the Nomberg Law Firm. You can always reach us at 205-930-6900. We're in downtown Birmingham. We're also at nomberglaw.com is our website, and you can find us on Twitter and Facebook. We'll be back again next Tuesday with another area of the law. And thank you for sticking with us for a little bit this morning, and we hope you have a good rest of your week.